Tonight's seminar is Alternative Dispute Resolution, Theory Meets Practice. I've heard Robert Riddell speak on this subject before with the MBA and the Institute of Building Consultants, and it's certainly of great interest. As you know, there's a lot of litigation in the building industry. There's a lot of alternatives to litigation, which Robert will discuss with us. Just a little bit of information. Robert Riddell is a partner with Gaydens Lawyers. Gaydens are specialist construction lawyers with a close association with the Master Builders Association, including the Legal and Contracts Committee, the Property Council of Australia, and the Institute of Arbitrators and Mediation Australia. What we'll do is that if you could fill in that form in front of you, the assessment form, and hand it in at the back desk, you'll be given CBD receipt. You'll also be given the papers that Robert's provided for us on the topic. As usual, please leave your questions until last, and so that I can walk around the room with a microphone and everybody can hear what the question is. If I could introduce Robert now, please, if you could welcome him. Thank you very much.
Thank you. Thank you for that warm welcome. Alternative dispute resolution to a lawyer is basically anything other than formal court proceedings. Until fairly recently, most disputes that arose out of building work were resolved in two main ways: as negotiation or court proceedings. Since in the last 10, 20 years, alternative dispute resolution has established itself as a realistic alternative, and the science of alternative dispute resolution has developed to the stage where now alternative dispute resolution is without doubt the largest slice of the dispute resolution pie, for want of another way of putting it. It's, as a litigation lawyer, you're mainly focused these days on alternative dispute resolution as opposed to formal litigation, although you might have some procedures with formal litigation ticking away in the background. I suppose that's like the grey storm cloud of litigation forming and keeping everybody real and focused on the need to get to a resolution. I'll be addressing 5 forms of alternative dispute resolution today. There's actually 7 forms I usually address with this paper, but it just gets too long, and given the time that we've got tonight, the final form that I often deal with, which is the thing called dispute resolution boards, I think we'll knock that one out tonight because it's not really something that's happening much, in this country at least. So the forms we're dealing with, I need to grab this, don't I? Is that working? No. Where what? I think you need it for the PA. That one's for the, yeah. Mediation, expert determination, adjudication, arbitration, and fast-track mediation, and a new variety called Med-Arb, which we'll get to and I'll explain. And moving forward as time goes by in the new millennia, I think we're going to hear a lot more about Med-Arb as time moves forward. Mediation. Anyone here been involved in a mediation? One. We've got a few. Mediation is becoming very popular. Expert determinations. We have some expert determination. Adjudication under Security of Payment Act. Not that relevant for residential building work. Doesn't apply where the principal lives in or intends to live in the property. Arbitration, well, arbitration is a bit like a private court case. Fast-track arbitration is a new form of arbitration that I'll be talking about a bit later on, and then there's Med-Arb, and I've had a few words about that. Now, desirable aims of ADR. Oh, there's the Dispute Resolution Board has come out after all. He's a bit shy. Look at that, ADR goals. First goal, resolve the dispute. Will the form of ADR that you select resolve the dispute? Secondly, is it cost effective? We don't want to throw the baby out with the bathwater. Is it fast? We don't want to be hanging around. We need to move on with the dispute. We need to get it resolved so we can focus on money-making activities. Is it confidential? That's pretty important. Of course, court proceedings aren't very confidential. Anyone can walk into a court. It's an open court. But some forms of ADR are favourable in that you get the thing done and dusted in a private and confidential way, and so it doesn't have such an impact upon reputation. Is it final? Now that's important. You're going to spend money on ADR, you're going to devote time and effort to it, so it's nice if it can be final and resolve the dispute so that you can move on. And finally, does it preserve the relationship with your client? May or may not be an issue, but it might be a client you want to keep. So you may like the alternative dispute resolution form to preserve that relationship. Some forms of ADR will deliver on these goals better than others. The paper tonight will visit the forms of ADR that I've mentioned and attempt to assess their performance against those goals, but we'll also explore the different forms, explain what they are, and give you an understanding of them. At the end of the evening you'll receive a copy of the paper, but we thought perhaps it's best if we focus on the presentation rather than reading the paper, as tends to happen if we hand it out too early. Mediation. It's a relatively informal process. It's aimed at enabling and empowering the parties to discuss their differences, have an appreciation of the other side's point of view, appreciate the issues in the dispute, and come to a constructive compromise. Mediation is not about winning or losing. Mediation is about reaching an outcome that you can live with and move on and resolve the dispute so that you can carry on and move on to the next thing. Many courts and tribunals will require, in disputes that have been lodged with them, that the parties go through the mediation process before the dispute will be heard before them. The courts love mediation because it represents a great way to administer the caseload. Firstly, it gets the matter out of the court list for a while the mediation's occurring, and secondly, it has a great hit rate, great strike rate, very impressive record of resolving disputes, particularly if you've got a good mediator. And the parties come along properly prepared, and I'm a lawyer, but I must say properly briefed by their solicitors about what to expect, what the process means, and how to get the most out of mediation. Now, it involves a neutral third party, a bloke or a lady called the mediator. Now, the mediator is not a judge. The mediator doesn't decide any issues at all. The mediator is there to assist the parties in discussing their issues. The mediator is a facilitator. Probably sounds all very new age, and it is. But the thing is that it works. The mediator's task is to help each party to understand the other party's point of view, to identify the matters in dispute, and to identify possible solutions. The mediator assists the parties to make a dispassionate, objective appraisal of the dispute and the respective merits of each party's position. Now, the mediation is a process that's very confidential. It's only the parties to the dispute come into the mediation room. Parties might move in and out of that room as the mediation proceeds through different phases. They might move into what we call a breakout room, and that's to discuss issues that have been put in private, away from the other party. And the mediator might move in and out of those rooms and have private sessions with the parties, trying to identify possible solutions to the problem. It's a bit like shuttle diplomacy in a way. The mediator's running around from room to room. Then the parties are brought back together from time to time to try to progress the parties, move them towards a settlement. Discussions in a mediation are without prejudice. That means that any proposal put in a mediation is non-binding and is not an admission of liability, and it's not an admission of liability until the parties sign off on either heads of agreement or a contract flowing from the mediation. Before a mediation, the parties have to sign a mediation agreement that provides that. that nothing is binding in a mediation until you sign off a settlement agreement at the end of the mediation that records the settlement that you've reached, assuming that you've reached a settlement. Mediation is good because they're very cost effective, and you can get involved in a mediation very quickly with the minimum of fuss beforehand. You might be involved in preparing position papers. That's a document that explains where you're coming from, what the dispute is about and your slant on it, and the parties might swap those position statements before the mediation. But generally the idea is to get the parties into the mediation room before the thing escalates too far, before too much cost is incurred. Sometimes it comes later than that. If a judge sees that a dispute hasn't been mediated, most often you'll find that the judge will refer the matter to mediation. And as a litigation lawyer, it's always an option. If a matter hasn't been mediated, all of the courts in New South Wales have the power to refer a matter to mediation. So it really is a good thing to try. Expert determination. Now, in the 1990s, a trend developed in construction contracts, not the construction contracts issued by the HIA and not residential building contracts, but not residential where the principal is anyone other than a developer. It does appear in developer contracts. But your mum and dad construction contracts won't have anything about expert determination, but the more sophisticated contracts with developers will. And expert determination it's to have disputes determined in a non-legalistic way by a person who is an expert in the discipline that relates to the dispute. If it might be a dispute where the appropriate expert will be an architect. It might be a dispute where the appropriate expert might be an engineer or a quantity surveyor, perhaps a programmer. Now, by about 2001, expert determination had actually become the most popular form of dispute resolution to be stated in the construction contract. A lot of construction contracts, commercial construction contracts, have clauses in them about dispute resolution, and they specify how disputes are to proceed. So by 2001, the majority of commercial construction contracts prescribed compulsory expert determination. So the expert should be chosen because of his or her skill in a particular subject matter. And it's ordinarily intended that the expert will use his or her own skill and expertise to determine the matter. Expert determinations are often determinations of disputes that are made on the papers. That is, each party prepares a statement of where they're at in relation to dispute and what their position is. The expert takes that away and will make a determination. Expert determinations often don't have any hearing as such with the parties in front of an expert. Expert determination is, I'll be going on to arbitration shortly, and arbitration's a bit like a privatised court case where the judge is not somebody being appointed by the government but someone who's appointed by the parties. But expert determination is really just a flexible form of an arbitration with much less in the way of procedural regulation. The most common form of attack of expert determination is the failure by the expert to follow the rules for the expert determination. There aren't always rules for an expert determination. The rules would come from the construction contract in that dispute resolution section, or sometimes a contract will say, in coming to his determination, the expert must apply the rules set down by, say, the Institute of Arbitrators and Mediators Australia for expert determinations. Trouble for an expert, if he doesn't follow those rules in coming to his determination, the expert determination might be attacked and it may be found not to be an expert determination of the dispute as was required under the contract. And if that occurs, it won't be binding. Now, an expert determination for the parties can be quite a wild and woolly ride because it's quick. Particularly quick if there aren't lengthy rules that have been adopted by the contract or incorporated by reference, such as the Institute of Arbitrators and Mediators rules. There have been attempts to constrain this wild and woolly aspect of expert determination, but the trouble is the more that occurs, the more rules you put up, the more procedurally complex it becomes and the more like arbitration and court proceedings it comes. So it loses that ability to be quick and flexible and really get to the nub of the problem. There is an argument that expert determination is more suited to more succinct, limited points of argument, as opposed to lengthy disputes with long factual histories and arguments about legal points. That's probably correct for the reason that the expert that is chosen is an expert in his or her field of endeavour, that is an architect or a quantity surveyor or an expert builder and the like. They're not going to have the skill set of a barrister or a judge to be able to take cross-examination of witnesses or to be able to give a decision on complex legal points. So expert determination is really better for well-defined disputes about technical issues and not big contractual disputes that go across, you know, the length of the contract and everybody hates each other and the relationship is broken down entirely. Now, that's it gives rise to a problem in that an example is the contracts that have been issued by the Department of Commerce, and their GC21 contract suite is an example where all of the dispute resolution provisions, or a lot of them, provide that all disputes under the contract must be determined by expert determination. Whereas really expert determination isn't going to be suitable for all of the disputes that might arise under the contract. It's one of those things that there's a bit of a mismatch, and that mismatch is often ends up to the disadvantage of the contractor. Because frankly, an entity like the Department of Commerce is going to be much better set up to be able to make the most of the expert determination process. So if you are involved in commercial contracts and you see expert determination, the tip really is to just make sure that it doesn't apply to all disputes that arise under the contract. It needs to be defined to specific, succinct technical disputes as opposed to general contract disputes. Moving on, adjudication. Now, adjudication has been a huge area of interest for construction lawyers in the last, since about 2001, when the Building and Construction Industry Security of Payment Act came in. For about 2 or 3 years, about all we did was adjudications and claims, payment claims and the like. Adjudication is about the cash flow for builders. It's a system where the principal pays now and argues later. It's to keep the lifeblood of the project going. Sorry, did I do the straw poll on adjudication? Could you put your hand up, anyone who's been involved in an adjudication here? We've got a few. Not surprising. Not so much of an issue in the context of mums and dads' residential work, but once you get beyond that, adjudication is a big issue. And the system of adjudication arose in response to what the the minister at the time, who I think was IEMA, it was in response to the un-Australian practice of not paying contractors for work they undertake. The minister said that the Act, that's the Security of Payment Act, was designed to ensure prompt payment, and for that purpose the Act sets up a unique form of adjudication of disputes, and disputes over the amount that's due for payment on progress claim. Parliament intended that a progress payment on account should be made promptly, and that any disputes over the amount claimed should be decided separately from payment. So it's through the Security of Payment Act, it imposed a statutory regime for the resolution of disputes in relation to claims for payment for construction work. The mode of determination of the disputes is not dissimilar to expert determination, but it's within a very limited time frame. The procedure is this, that the claimant serves a payment claim on the person liable to pay. We'll call that person, we call them the respondent. The respondent can provide a payment schedule if the respondent intends to pay less than the amount claimed. And that payment schedule has to set out the reasons, how much the respondent intends to pay and the reasons why that is less than the amount that's claimed. So once the claimant receives that payment schedule, the claimant can decide whether it'll accept that amount of money or whether it'll dispute it. And if it's disputed, it gets passed on to a thing called an authorised nominating authority. Don't worry too much about that, but the ANA appoints an adjudicator. The adjudicator will nominate his or her acceptance, and when that occurs, the adjudicator has to determine the payment claim within 10 business days. And in that process, the respondent gets an opportunity to make some submissions in response to the application to the ANA. So it's a pretty quick process. 10 business days from the application. It can be extended by agreement between the parties, but in my experience that probably only happens in about 1 in 3 or 1 in 4 adjudications. Now the decision of the adjudicator is binding, and the respondent has to pay the amount that's determined by the adjudicator. The respondent can dispute that amount, but it's on the basis of pay now, argue later. If you don't like the amount, you can go to court and ask for restitution, that is, get the money paid back, but you've still got to pay back the contractor. Security of payment has had a profound impact on the way disputes or payment disputes in the construction and engineering industries. Everybody in these industries has to be conscious of this act. Anybody who is doing construction work, basically other than mums and dads residential building work, needs to know about the Security of Payment Act. It's a great opportunity for builders to enhance their cash flow, and it's also a great risk for respondents if they don't know what's happening, because if they don't respond to a claim, they can find themselves liable to pay, and they can't hold that up. They can take it to court later on, but they can't hold up the payment. If they think they've paid too much, they can take it to court, lodge a statement of claim and argue about the contract dispute, but it doesn't hold up payment. So it's pretty serious stuff. Arbitration. Now, arbitration's a bit like a court case, but it's not in a courthouse. It could be something that's undertaken in a room like this, or a room much smaller than this as well. All states and territories of Australia have a Commercial Arbitration Act. Arbitration will be relevant if your contract provides for arbitration as the mode of dispute resolution, or the parties agree to proceed by way of arbitration once a dispute arises. If those two things don't occur, you'll never end up in an arbitration. You can't be compelled into an arbitration unless you've agreed to it. But you can have agreed to that mode of ADR in advance, that is at the time you entered into the contract, as opposed to the time the dispute arose, which might be much later. There are advantages to arbitration, the perceived advantages, that it's supposed to be less expensive than litigation. But the trouble with that is that there are some aspects of litigation that are subsidised by the state. The state provides the courthouse. The state provides the stenographer. The state pays the judge. The state pays the power at the courthouse. With an arbitration, all of that's paid by the parties. So I don't know. They used to hold it out as being cheaper than litigation, but I'm not quite sure whether that is in fact an advantage now. Less formal than litigation is another perceived advantage. I think it's right. Well, the arbitrator won't be wearing a wig. The advocates for either side won't be wearing gowns. However, arbitration has tended to mimic litigation in other ways. Arbitrations these days tend to have very long pre-trial procedures. Lots of directions, hearings about statements and evidence and applications and subpoenas and everything else. So in terms of formality, wigs and gowns, certainly the case, but in terms of procedure, it's become almost as formal. And I've spoken about the pre-trial bureaucratic delays. Well, no, I haven't spoken about them, sorry. What I mean by this is the traffic jam, or it's often a traffic jam that we call a court list. You might have hundreds of matters awaiting a hearing in a court list, and that can cause great delay. It can cause delay for months or at times years before disputes are listed for hearing, particularly long disputes where they need to take a lot of time out of the court calendar. Now, if you're paying an arbitrator to do it for you, it's unlikely that you'll encounter that type of delay. In selecting your arbitrator, hopefully you select somebody who's technically proficient in the area jurisdiction of the dispute. However, a judge is technically proficient in the law, and that's about all. And privacy and confidentiality. A court, open court, anyone can walk in and out of the court unless there's some special order in relation to confidentiality, which you're unlikely to get in the context of a construction dispute. Arbitrations are confidential. You can, the traffic flow is controlled by the parties as to who comes in and who is allowed to view what occurs at the arbitration. Part of the paper relates to international arbitrations, and I don't think there's probably any need to go into that here. It's really for a different audience, so I'll pass through that. But arbitration was once a very popular and effective means of privately resolving disputes in the commercial world and in the building and construction field. Had the advantage of the person of the arbitrator being a person with expertise in the particular discipline of the subject matter of the dispute. But over time, the procedure has slowed. Although there's only limited grounds upon which an arbitration can be appealed, arbitrators have tended to get very nervous. Fear of arbitral awards being overturned has featured writ large in the arbitration process. Also, the pre-hearing procedures established by arbitrators have tended to mimic those of litigation. Extensive discovery of documents, crunching through volumes of files, which are often irrelevant. Arbitrations these days also tend to involve multiple pre-hearing conferences and applications. And insistence on court-like pre-trial procedures has been insisted upon by our own courts who review arbitrations, the courts that are asked to supervise what's happening in litigation, in arbitration, and that They're asked to do that by the parties when they appeal the outcome of an arbitration. It's all a shame really, because parties nominate, well, they used to nominate arbitration because it wasn't like litigation, but as time has passed, it's tended to mimic litigation. But there's a light on the horizon, and we might need to just skip through a few slides at the moment. We can go through, this is an international arbitration that we don't need to deal with, so keep on going. Okay, that's where we want to go. The Institute of Arbitrators and Mediators Australia, it's a bit like an industry body really of arbitrators, and it does continuing professional development just like this organisation. It's also maintains the registration and accreditation of arbitrators, but they've tried to revive arbitration, a push to reinvigorate it. On the 1st of June 2007, the Institute of Arbitrators and Mediators issued the new arbitration rules. Now, the first of the new rules was a thing called the overriding objective, and that is that arbitrations be conducted fairly. Expeditiously means fast and cost effectively, in a manner that's proportionate, has regard to the amount of money that's involved. It's sensible, isn't it? We're not going to throw the baby out with the bathwater. The complexity of the issues and any other relevant matter. Now, the intention was that the overriding objective will influence the way the rules, these new arbitration rules are interpreted by both the parties, the arbitrator, and any court that's later on reviewing the arbitration in an appeal process. Now, these rules, these new rules, the Rule 14 is the general duty of the arbitrator, that the arbitrator must conduct the arbitration in accordance with that overriding objective we were just talking about, and shall adopt procedures suitable to the particular case, avoiding unnecessary delay and expense, so as to provide a fair, expeditious, cost-effective process for determining the dispute. And that the arbitrator shall give each party a reasonable opportunity to put its case and respond to any of the opposing party. We call that natural justice. And a reasonable opportunity to be heard on the procedure adopted or proposed to be adopted by the arbitrator. Arbitrators have a fair degree of control what happens in the arbitration. So there's the overriding objective again. That's about the cost effectiveness and having regard to the amount of time that's involved. So that's the arbitrator has that, and then the parties themselves, in the rules it refers to the parties, and they have to do everything to ensure that the arbitration is conducted in accordance with the overriding objective. And the parties must comply without delay with any direction or ruling by the arbitrator as to procedural or evidentiary matters, and I've just spotted my lemon squash. Now, an arbitrator gives things called procedural directions, same as a judge does. You know, before a hearing, parties go off court for directions as to what should happen. Rule 17, procedural directions. In order to give effect to the overriding objective again, the arbitrator shall have the widest discretion to exercise procedural control, blah, blah, blah. So the overriding objective is there, not an overriding objection. So you can see how those rules weave back for that overriding objective through to conduct the arbitration fairly, expeditiously and cost effectively, having regard to the amount of money involved, the complexity of the issues and any other relevant matter. All sounds very sensible. And it's now being applied with arbitrations and it's having some success. But that's not the most exciting development. There's more. The most exciting aspect of the new arbitration rules is the option of applying Schedule 2 to the rules, and that is called the Fast-Track Arbitration Procedure. I'm just wondering, oh, it's MedArb is the next slide. Okay, I haven't got any slides in relation to Fast-Track Arbitration Procedure, but it's pretty exciting stuff and a bit counterintuitive. The essence of fast-track procedure is that an award must be made within 150 days of the time of lodging of the application for an arbitration. 150 days, much better than a court case or an arbitration that takes years. It's certainly the case. Time frames are tight. The applicant must have it makes the application, then it must have all its evidence on within 20 days after making its application. The respondent has another 20 days to put on its material. The idea is that the arbitrator again make its determination on the basis of the papers rather than having a hearing. We'll only have a hearing in the fast-track arbitration where it's really necessary to have that hearing, where the arbitrator can't make a ruling on the basis of the papers in front of him or her. Now, if there is to be a hearing, it's to be conducted as a stop-clock affair. A bit like a game of chess. Bang, your time starts now. None of this filibustering, no lengthy cross-examination of witnesses, no lengthy submissions and the like. They fix the amount of time that the representatives of the parties or the parties themselves have in front of the arbitrator, which is a great idea because there's nothing like that to focus the attention on what's relevant. The parties' representatives in a fast-track arbitration will have to be very well organised and very concise in the way they present the material. But the Arbitrators Award still has to, and that's the judgment, the Arbitrators Award is what we call the arbitrator's judgment, must still explain the reasons for the arbitration's decision. But the extent to which the arbitrator is required to do that will depend on how much time of that 150 days is left at the time the parties' cases are completed, or that the presentation of those cases are completed. If there's only 5 days left, it's going to be a pretty short, brief, pithy determination. If there's 50 days left, it might come across in considerably more detail. But the thing is, these fast-track arbitration rules entitle the arbitrator to do that, so the parties can't go off and complain about it to the court. Now, these new rules are new, but they are being increasingly incorporated into commercial building contracts and engineering contracts. At Gaydens, we are incorporating the fast-track rules for disputes. Anything under about $300,000, although it's subject to instruction. Some clients prefer $500,000 because they want to get into the nub of the dispute. Others are a bit more nervous about the new procedure, and we've had one contract go out recently at $150,000, or disputes up to $150,000 will be fast track, and beyond $150,000, just arbitration under the new rules where that overriding objective is the main guide to getting the thing done and dusted. Anyone interested in that, the Institute of Arbitrators and Mediators, they have a website, you can Google it. You can download these arbitration rules for free. They're there. They're there for the greater good of mankind and promoting, no doubt, the services of their arbitrators, who they'll refer to and claim a commission at the time accounts go out. Now, the good news is the last variety of alternative dispute resolution that I'm going to present tonight is MedArb. This is the new kid on the block of dispute resolution, although his mum's not letting him out very much yet. He's Chinese, so he's probably in front of his computer. He's somewhat counterintuitive in mixing mediation with arbitration, but his friends know him as MedArb. It involves the same neutral conducting a mediation, and if the mediation is not successful, an arbitration. The same bloke or lady runs the mediation followed by an arbitration. If agreement is reached at the mediation, you don't need an arbitration. They still call it MedArb because it's in anticipation of an arbitration. Why take the process any further if the thing is settled? Now, the dispute resolution intelligentsia tell me that you need the right kind of dispute for this to make MedArb work. It's a strong candidate in the context of unlocking disputes in ongoing commercial relationships and with parties who are open to creative problem solving, which is increasingly the case as people learn more about alternative dispute resolutions. It has issues, and I wonder whether there's a slide. What's the next slide? Oh, there we go. The concern is that the parties might be inhibited in the mediation process because they know that the dispute is going to go to arbitration, and they may not be as open and willing to communicate as they might be otherwise, which is fair enough because people can be guarded if they think they're going to court. They want to, drop their bombshell at the right time. The next fear is the mediation being exploited as just simply a preparation for the real dispute resolution, which will be the arbitration that's followed. It's a bit like just an information gathering process. Thirdly, the mediator's persuasion being taken as pressure or an implied threat by a mediator to make an adverse decision in the arbitration that's to follow. Fourthly, perceived bias, that is, that the party doesn't have the benefit of natural justice in respect of representations made privately in a mediation. Just let me explain that for a moment. That I mentioned mediations where we have these breakout rooms. You have the main mediation room where all the parties and the mediator are present. The parties break out to talk about proposals or offers or consider an issue that's been raised. Often the arbitrator will follow the parties into that. Not the arbitrator, the mediator will follow the parties into those breakout rooms. There is a concern that the parties, they want to have the neutral, the mediator / arbitrator, present with them all the time so that they know and can make submissions in respect of everything that he's told. Managing these concerns. Where these issues are concerned, it's been suggested that the following approach could work, that the parties enter into an arbitration agreement which attracts if you enter into an arbitration agreement, it attracts the operation of the Commercial Arbitration Act, which means that what happens is going to be binding. That the arbitration agreement provide that that the mediator can mediate before conducting the arbitration, that the arbitrator can hold private sessions during the mediation with the usual confidentiality requirements applicable to that, and that upon the conclusion of the mediation, the arbitrator tell the parties whether he or she thinks he's able to conduct the arbitration impartially, and the arbitrator has the option of not proceeding further if they don't think they can. But also the parties, regardless of what the arbitrator says, the parties have the option of pulling the pin on the arbitrator. If they don't want that arbitrator to do the arbitration, they can select another arbitrator. You see, so that manages the concerns that arise out of that process. Now, if neither party objects, then each party must expressly consent to the med arbiter proceeding further. Now, I'm not going to go into dispute resolution boards. How are we going for time? No problem? Good. Now, what I want to do this is going to be put up on the screen as well. So don't be too concerned if you can't read it, but it just helps me being able to read it from here. Now, the question is whether mediation is going to resolve the dispute. That's something that depends on the parties on whether they can reach a compromise or not. Now, I always know ultimately that litigation is going to resolve the dispute. The parties may not be happy about the hot or cold outcome of litigation, but mediation, it's not so. It's one of those, you can't be sure whether mediation is going to resolve the dispute. It's got a good hit rate, but it's quite possible that it won't. So I need to put a cross in the mediation column. Now, mediation, is it confidential? Does anyone have a view on whether a mediation is likely to be confidential? Yes, it is, because the only people that come to the mediation are those parties to the dispute. They're the only ones who will attend. So it is confidential. Is mediation relatively quick? Yes, it is. Cost effective? Compared to other dispute resolution modes, it certainly is. Now, it's an interesting one. Does mediation tend to preserve the relationship between the parties or destroy the relationship? Preserve, very much so. Very much so. It can be a real healing process, mediation. Final remedy, it's a hard one. So if you do, in a mediation, reach an outcome, is it likely to resolve the dispute, the outcome? Is it a final remedy? Probably not a fair question, but you can't appeal the outcome of a mediation. Whereas in litigation, you can always, throw it up to the next court until you end up at the High Court. Well, you may not get the High Court's interest. Maybe you stopped at the Court of Appeal. But yeah, it can be a final remedy, provided that you actually get the resolution. If you get a settlement, the hope is yes, that's it. Expert determination. Will an expert determination resolve the dispute? It will, because it's a bit like a judgment, what comes down from an expert. He gives you the resolution. Is an expert determination confidential? Well, the only people that go to an expert determination, like an arbitration, like a mediation, because it's a private process, are those you invite along. So, yep, confidential. Expert determination quick? Yep. Usually, it can be certainly longer than a mediation, but I'm going to give it a tick. I think it cost effective, generally, compared to certainly other options such as litigation and arbitration. It's cost effective. Expert determination. Is expert determination about preserving the relationship? It's not really. It's an adversarial process. It's one against the other. So it fails there. Expert determination as a final, is an expert determination intended to finally resolve the dispute? It is. Now, well, arbitration. We've got arbitration here. That's arbitration in its old form, not the fast track form. Old-fashioned, good old-fashioned arbitration. Will that resolve the dispute? Well, it will to the same degree that a court decision will. That it's either on or off with an arbitration. You either win or you lose, but at least your dispute is resolved. Is arbitration confidential? Private process. The only people that go there are the ones that you invite. Is old-fashioned arbitration fast? Certainly not. Cost effective? Gets across. Does arbitration preserve the relationship? Unlikely. Again, arbitration is adversarial. Just as adversarial as litigation, perhaps not as adversarial as expert determination, but it certainly gets across. Arbitration is a final remedy. Generally it is. There are some appeals that can come from arbitration, but it's just as final as litigation. So it is final remedy. Now I've made a real mess here, but this is actually adjudication. Does adjudication resolve the dispute? Or does it just get the money flowing? Yeah, it's not. Adjudication isn't a final resolution of anything really. The purpose of adjudication is just to get the money flow going so that the contractor can continue to survive and continue to perform work. So it won't be. Is adjudication confidential? Private process. So it is. Only the parties get to see all the documents and get involved. Is adjudication quick? Yep. Cost effective? Usually, I've seen adjudicators charge $100,000 for a determination. But usually cost effective, so I'll give it a tick. Was he a lawyer? No, he was a professional adjudicator. In fact, he was the president of the Institute of Arbitrators and Mediators for a while. And he runs a group called Contracts Administration. Adjudication, does it preserve the relationship? Believe me, it doesn't. The parties hate each other, at each other's throats when it comes to adjudication. It depends whether win or lose, isn't it? But the parties, it's such a sharp process. Oh, preserve relations. Oh, definitely not. Resolve the dispute and final remedy. Well, we know adjudication is not a final remedy, because if you're not happy with it, you can always have a contract dispute in the court and pay more lawyers' school fees. Now, fast track adjudication with a stop clock, hearings, 150 days, done and dusted. Will that resolve the dispute? Yes. Give it a tick. Confidential. Only those invited to the show can attend. So it is. Quick. It's quick. Cost effective. I didn't mention anything about cost effective, so it's probably not fair, but compared to other modes of dispute resolution such as litigation and arbitration and expert determination, yeah, it's pretty good. If expert determination gets the tick, fast track adjudication will get the tick as well. Preserve the relationship, an adversarial arbitration. Is that, ooh, shouldn't have touched that, should I? So, fast track adjudication, preserve the relationship, big love in? Not at all. Possibly better at preserving the relationships than a full-blown arbitration that takes 2 years, but not real good. The aim is not to preserve the relationship between the parties. And fast track arbitration is a final remedy. And finally, litigation. Does litigation resolve your dispute? Maybe not the way you want it resolved, but that's what it's all about. Is litigation confidential? Read the Sunday Telegraph. In fact, read the Telegraph any day. Plenty about litigation in there, not at all. Litigation's fast, isn't it? All done and dusted in a few days? Not at all. Cost effective? Preserve the relationship? It's not scoring that well, is it? Final remedy? Yeah, well, it is a final remedy. Subject to appeal. So there does appear to be a trend that the more formal the dispute resolution procedure, the less likely it is to deliver on the goals. Mediation is really the most effective of delivering on the goals. Lots of ticks there. Expert determination, well, only one cross. Arbitration, more crosses. Fast track should be up here. I've got these completely round the wrong way. I apologise for that. But that's a much less formal procedure than full-blown arbitration. But you'll see the most formal form of dispute resolution is litigation. It scores very poorly on those goals that we're looking at. The further one goes along the spectrum of complexity and compulsion, fewer of the ADR, alternative dispute resolution goals, will be achieved. I think the message in this is that the simpler forms of ADR should be attempted before heavily investing in arbitration or litigation. The costs of doing so are not great, but the opportunity costs of not doing so can be considerable. The trend also suggests that the parties to disputes will benefit from engaging in the simpler forms of ADR at an early stage, rather than leaving it till shortly before the arbitration or the court hearing. Now, that completes the formal part of the presentation. I'm happy to take any questions anyone might like to raise.
Security of payments. How much clout does that have?
You're probably referring to the problems that people encounter in trying to enforce adjudications.
Yes.
There are limits on enforcing, on the things you can do to enforce an adjudication. You can't enforce an adjudicated determination using winding up proceedings, but you can enforce an adjudicated determination using writs. So if the principal has property, whether it be movable chattels or real estate, eventually you'll get your money. There's always the danger that you'll get a security of payment adjudicated amount against a party who has no assets. But that's the same with any judgment. If you get a judgment against someone who hasn't got money, you've got an empty verdict. And that's an assessment you really need to make before you invest too much time and money going down the adjudication track. In fact, it's something you should probably investigate before you enter into a construction contract with the principal at all. Of course, things change as you move along. The principal can go bust while the projects can start off as though they're smelling of roses and end up smelling of something else. But there's not much you can do about that. The principal's financial circumstances are out of your hands. But it just goes to show that it's worthwhile doing a few investigations up front to make sure that the principal has got the clout to pay your progress claims.
Second question, if I can please. As a builder, can I use the Security of Payments Act against a client when I make a progress payment or make a claim for a progress payment?
Depends on who your client is. And yes,
Right,
builders are allowed to use it. You can't use it against mums and dads when the building work is upon their dwelling.
Why not?
That's
What makes it?
a limitation in the Security of Payment Act.
Right.
They thought that the procedure was too complex for mums and dads to cope with. MBA in New South Wales want it changed. I don't think they've got a snowflake's chance in hell of that occurring. I don't think it's going to happen for dwellings where the principal lives in the dwelling.
Okay.
Where there's a developer building the dwelling, multi-level development, or developing it as a commercial enterprise, then security of payment is open and available. Those procedures are there and available for builders to take advantage of them.
I asked that question because I know of several cases that are taking place where the Department of Fair Trading are involved and the clients have been totally wrong in their assessment of what remedial work should take place, what hasn't been done by the builder, etc. But the process has taken 6, 8, 12 months and the builder hasn't had that cash flow because it hasn't been paid.
Through the CTTT, it could take years.
Yes.
Yeah,
So my question was that, I think it's a good thing if we could use the security of payments to try and further our ability to get paid quicker.
There are some Australian states where it is available in that context, in the mums and dads context. Just not New South Wales, so it's not much
Thank you.
use in that context.
Just to add to the last question, probably more of an answer, I've got about 11 cases if the Securities of Payments Act would be applicable to residential building. There's probably a fair reason why it's not, because how are you going to act on anything in a short amount of time if you got 250,000 claims in the first week that it became available, And we all heard about that. But I just thought I'd throw that in.
The question I was going to ask, with mediation, what's the sort of success rate?
Somewhere between 70 and 90%.
So if any of our builders have some sort of dispute, would you recommend that they would look at mediation before looking at what's in the contract as far as
Dispute
resolving
resolution.
it?
Well,
Yep.
you should always have a look at what's in your contract,
Yep.
so that you know where you're headed. You want to be looking forward. But certainly before you engage in any formal form of dispute resolution, you should give the mediation a go to see if there's not some middle ground. But I think it helps a lot if you get a really good mediator. You need to know that the person you're getting really has the skills and the persuasive nature to bring the parties together. You can rely on mediators that issue out of the CTTT, if you like, but that's not really the cream of the mediators. You're better off to try to get agreement on somebody who might be more expensive, but the outcome, if you get a good outcome from a mediation, it's certainly the really money very well spent. Yeah.
Robert, thank you very much.
Pleasure.
Can we put
Thank you.
hands together? Thank you.
Thank you.
Okay, that's the end of our presentation. Just a couple of things. You've got your assessment sheet, which you'll need to fill out, and obviously you've filled the back out now, based on the last part of the presentation. If you weren't here at the last CBD meeting, grab a DVD with a questionnaire, fill it out, and you'll get some more CBD points. Also at the back on the left-hand side, if you see Chris, he's got one of these books for you if you haven't been given one. It's lined, good for site notes, etc., as well as the presentation that Robert gave us there in a hard copy. With the CPD now, you're probably aware of, you've all had information passed on to you by the department that we only need 12 points per year. Our meeting tonight provides 2. So simply if you turn up to 6 meetings a year here, you'll get your 12 points. I just had to say I did notice that one of our new members, Paul, I won't say his last name, when Robert asked about the different types of options open to us, Paul seemed to put his hand up for every single one, so anyway, I just noticed that. All right, that's all, guys. Thank you very much, and we'll see you in 2 months' time. Thank you.